Very warm good evening to all. Today's topic is again one of the, I would say, very easy as well as important topic of the bail. And the feature of this bail is that it's the default bail. Now, when we call it default bail, does it mean it is because of default? The answer is true, that it is by default that you get a bail for your client. Now here, when you are asking default bail, you have to go through section 167 of CRPC. Now, why it is called default bail? The reason behind this, that whenever the investigation agency defaults in filing the charge sheet under section 173 of 73 of CRPC, the accused is entitled to default bail. Now, when we say default bail, there are some conditions which has to be fulfilled before we apply for default bail. Now, to go through the same, we will understand what is section 167 CRPC. Now, 167 CRPC says that accused cannot be always kept in custody. The police has the unfettered power, uncontrolled power, where they can go on investigating. But this 167 CRPC is controlling section where it says that after some time the accused is entitled to bail. Now, if we look at the section 57 of CRPC, it says that any person cannot be detained in the police station after 24 hours. And after once the 24 hours are covered or are completed, he or she has to be produced to the nearest magistrate court. And if there is no magistrate court available nearest, then to the executive magistrate on which the powers of the magistrate, judicial magistrate are conferred. Now, in this case, suppose after 24 hours, the police wants to keep the accused in custody, they have to go and apply to the magistrate. Now, 161 CRPC says that at the most 14 days to 15 days custody. The word he uses 15 days custody. Normally we speak when we go to court 14 days, 14 दिवसाचा remand दिला, 14 दिवसाची custody दिली, we speak like that. Now here 15 days custody given. On 15th day, he has to be accused, has to be produced before the court again. This will go on, but the CRPC, when it was enacted in the 18th century, it was said that the police cannot have the unfettered power and only the investigation has to be completed within 24 hours. If they cannot complete, then they have to bring it to the accused to nearest police station, nearest magistrate court. Now, magistrate will remand for 15 days. So as the time went on, and after the British rule also it continued, and due to anxiety of the legislature or do not know whatever it was, it is mentioned in one of the Justice Lokur judgment, which we will discuss in as the session progresses, that legislature wanted that the investigation should be completed within some time limits. So CRPC 167 is giving a time limit. Now this time limit is 60 days and 90 days. Now 60 days is for where there is no death penalty and where the punishment is below 10 years and all the other offenses. Now 90 days is period is where the death penalty is there. There is a life imprisonment and also where the punishment, minimum punishment is 10 years. So 90 days period is given to the police. And after this investigation is completed within 90 days, the police has to file the charge sheet on the 90 days. If the police do not file the charge sheet on 60 days as applicable or the 90 days, the accused has the indefeasible right. Indefeasible, I would say, indefeasible means that right cannot be overturned or taken by or cannot be frustrated by any other law. And he will have an indefeasible right to have this default bail to be obtained from the court. Now for this default bail, he has to make an application before the charge sheet is filed. That is, if 90 days are over on 91st day, if 60 days are over on 61st day. And there are some cases, that is UP, that is NDPS Act, and also another Unlawful Activities Prevention Act. This act, under these two acts, if you see the or also there are some other acts where NIA is investigating, that's National Investigation Agency. The time limit for filing charge sheet is up to 180 days. Now, in those cases, the police can investigate up to 180 days, and the accused can apply for default bail only after the completion of 180 days. Now, once these 180 days are completed, the accused can apply for bail. Now, in normal course where Indian Penal Code sections are applied, or some regular sections of the local crime acts are applied, there is a possibility that the 60 days, 90 days period is counted. Now, the another situation where this 61st day, 91st day, 181 days is that the bail application has to be preferred before the charge sheet is filed. Suppose you are for the accused and 90 days period is also over, and by any chance you are unable to make an application as a defense counsel before the honorable court, and 95 days are passed, and on the 95th day or 96th day or 92nd day, the 92nd day, the police files the charge sheet, then the accused loses the situation, or I would say opportunity of the default bail. So you have to be very visible as a lawyer when 90 days, 60 days or 180 day period is covered. Once the charge sheet is filed under section 173 CRPC, the court magistrate concerned cannot under 167 CRPC give the default bail to the accused. Now, this is something very serious, so you have to be vigilant about your right. There is a case of actor Sanjay Dutt. In this case, he did not avail of the police did not file the charge sheet and did not avail of the bail, default bail. And after the charge sheet was filed, there was no question that he can be granted bail. The matter went to Supreme Court. The Supreme Court clarified in Sanjay Dutt's case that you have to obtain the default bail before the charge sheet is filed, whether it is 90 days, 60 days, or 180 days. So you have to be vigilant. You have to be very careful as an accused lawyer when the period of completion of the investigation, that is 90 days, 60 days, or 180 days, is going to be completed. So the date of arrest, that is date of arrest mentioned in the remand application, is very important for all of us to know. And from that day, remand application day, count 60 days or 90 days or 180 days. If by any fault, if you are unable to make an application and the investing agency comes in action and files the charge sheet, you loses your accused, the client loses the right to apply for default bail. In Sanjay Dutt case also, this Supreme Court clearly clarified that he has to apply. Now, there is also one other situation that you may file the application for default bail on the same day charge sheet is filed. Now, here the Supreme Court has again clarified, though there was a Justice B.K. Agarwal's dissenting judgment is there, but now the situation is again clarified that if on the same day the application for default bail is made and the investing agency also files the charge sheet, then also it becomes a statutory right of the accused to obtain bail. Statutory, the meaning is that it has been given by the law. So it is a fundamental right also under Article 21 that anyone cannot be kept in custody without the following the due procedure of law. Here, what happens that if the charge sheet is filed same day, bail application is also filed same day, then also this application for default bail will be considered, and not just because charge sheet is filed, the accused will not be entitled to the default bail. So court has been very liberal. This has been the recent judgment of M. Ravindran, as an intelligence officer, 2020, has also said court cannot be rigid or they cannot be very formal in the approach. Default bail is the accused right. This is what has been said in the recent judgment. Since 2017, there are many judgments which are supporting. Recently, a Bombay High Court judgment also came, which is Sainath Bapu Salgar, State of Maharashtra of 2021. Here the matter was that the accused was charged under POCSO. Also, there was 376. Now the charge sheet was also filed on same day, on the day when also this accused applied for default bail. The matter went to Bombay High Court, and Justice Bharti Dangre has written a very beautiful judgment. I would like to share with all of you one para 14 from this judgment, which will clear the complete picture. Let me share with you. This is a judgment from Bombay High Court, Sainath Bapu Salgar versus State of Maharashtra. It was recently pronounced few days back, that is 4th August 2021. Here the charges were, if you can see the screen, 376, 363, 366A, also POCSO Act. See here, when we are discussing the default bill, it is just a technical thing, and nowhere we are going to see the facts of the case, what are the charges and all that. I will read out one para here. Just a minute. The latest decision of the Apex Court has clarified the position further. In the case of M. Ravindran versus Directorate of Revenue Intelligence reported in 2021, it has been reiterated by the Apex Court that the indefeasible right to default bail under Section 167(2) is an integral part of the right to personal liberty under Article 21 of the Constitution. And the safeguard of default bail contained in the proviso of Section 167(2) is intrinsically linked to Article 21 and is nothing but a legislative exposition of the constitutional safeguard, and that no person shall be detained except in accordance with rule of law. The three judges bench of Apex Court threw light on the accused right to default bail, and as to whether it gets extinguished, जो खत्म हो जाता है, by subsequent filing of an additional complaint. The following observation of their lordship needs a reproduction. Having considered both opinions, we have arrived at the conclusion that the majority opinion in Uday Mohanlal Acharya is the correct interpretation of the decision rendered by the Constitutional Bench in Sanjay Dutt. The decision in Sanjay Dutt merely casts a positive corresponding obligation upon the accused to promptly apply. As I said, you have to apply immediately. Promptly apply for default bail as soon as the prescribed period of investigation expires. In Sanjay Dutt's case, he did not apply promptly, and Supreme Court said, once the charge sheet is filed, you lose the right to apply for default bail. As the decision in Hitendra Vishnu Thakur expressly cautions, the court cannot suo motu grant bail without considering whether the accused is ready to furnish bail or not. This is an inbuilt safeguard in Section 167(2) to ensure that the accused is not automatically released from custody without obtaining the satisfaction of the court that he is able to guarantee his presence for further investigation or for trial. This means bail is given only when he can furnish surety and he can give good guarantee that he will be remain present for the further investigation and remain present for the trial, as the case may be. Further, as the majority opinion Rakesh Kumar Paul pointed out that there could be rare occasions where the accused voluntarily forfeits his right to bail on account of threat to his personal security, outside of remand or for some other reason. The decision in Sanjay Dutt clarifies that once a charge sheet is filed, such waiver of the right by the accused becomes final and Section 167(2) ceases to apply. So here goes that you have to apply immediately once the period is over. In between, the investigation agency, maybe police authorities or CBI or CID, comes and file the charge sheet, then you lose the right for default bail, because this is 167 CRPC is only up to picture where it is charge sheet is not filed. Once charge sheet is filed under Section 173, 167 cannot be applied. Now, there are some other things also which we need to look into this. There is a Rakesh Kumar Paul's judgment of the Supreme Court of 2017. Now here, there was some dispute about this matter went up to Supreme Court because there was some dispute in, there was also other acts other than IPC, and it was said that the punishment is up to 10 years or should be less than 10 years. It is, whether it will be 60 days or 90 days. See, the 90 days period, the three conditions are required. that it should be death penalty for the offense, or it should be life imprisonment, or the minimum punishment prescribed is up to 10 years. So minimum will 10 years will be granted to the accused. In those cases, 90 days period will be there. But now if it is less than 10 years, so minimum and less than 10 years, these two words, these two sentences are differentiated in Rakesh Kumar Paul versus State of Assam. So if it is less than 10 years, it will be 60 days. Here Rakesh Kumar Paul court said that less than 10 years, it will be 60 days. So there was a dispute over this matter. And when it is matter, because there's also corruption charges. And due to this matter went up to Supreme Court. However, the court said nothing doing because the minimum punishment is 10 years. So 6 years period will be applied. So he was granted the bail. And that is, again, it was reiterated by the Supreme Court. It is an indefeasible right which accrues to the accused when charge sheet is not filed. Now here I would like to quote one quotation from Benjamin Franklin, which has been quoted by Justice Lokur. Now this was also again in the Rakesh Kumar Paul. Any society that would give up a little liberty to gain a little security will deserve neither the security nor the liberty. So अब छोटी सी चीज के लिए मतलब we cannot take away the client's right or accused right for bail. So default bail is one such kind of, I would say, control over the investigation agency that they cannot keep the accused forever in the custody, and they are given a time limit in which they have to complete the investigation. They cannot frustrate the accused right to bail, which may be default or regular bail, by just keeping him in custody and not filing the charge sheet. So somewhere the legislature intention was that they, under 167 CRPC, if we write the period, they have to bring the charge sheet to the court within some time limit. And that from there, this 60 days, 90 days, or 180 days period emerge. Now again, we can see one more judgment of Fakre Alam versus State of UP. This is also a very recent judgment. Now here the charges were 420, 467, 468, 470, 120B. Now for this, 90 days were enough for default bail to be applied. Now here this person, accused lawyer, applied for default bail after 90 days were over. And because there were UAPA were applied, that is another act, and where the punishment was more than that, 7 years. So they were saying that no, because the punishment is minimum is 10 years and he is likely to be convicted, and UAPA and charge sheet is not filed, so he cannot be granted the bail. However, the matter went to Supreme Court, and Supreme Court said that if you have not taken sanction and if you have not filed the charge sheet, they filed one charge sheet and they wanted to file additional charge sheet because they were unable to get some sanction from the government, because for Unlawful Activities Prevention Act, you have to obtain the state government sanction. Now here there was this sanction was not coming through the government, and because of this person was allowed bail by the Supreme Court, which said that he is entitled for default bail, and his petition was allowed. Just because the state government may not give sanction possibly, or there is a possibility that they may not file charge sheet for, they may ask for another additional time. So this cannot go on as the investigating agency wants, and he was allowed to have a default bail. So this is one more case of 2000, I would say 21 only. And another is Sainath Bapu Salgar, which we have already discussed. There are Uday Mohanlal Acharya's case also, which also says charge sheet and bail applied on the same day. Then also bail application has to be considered, though there was a dissenting judgment in this judgment, 3-bench judgment. Now, further few things I would like to tell here, that there is a 57 CRPC which says that the investigation has to be completed within 24 hours. If not completed, the accused has to be brought to the police station, to the nearest magistrate. Now, when there is a 15 days time is given, and this can continue for longer period, and the basic idea behind the legislature was that if the investigation is not completed within 24 hours, the CRPC says that the accused has the indefeasible right of the bail, that is default bail. And in case At the same time, in the High Court or the trial court or the Supreme Court, there is a bail application pending. In Supreme Court, of course, it will be a special leave petition. Bail application will not go directly. Everything to the Supreme Court goes by special leave petition. Now, if this is pending, the default bail will take a priority, and once default bail is granted to the accused, all the bails will be like they have to withdraw the applications here. So default bail is that important, that more than regular bail. Only thing you have to be vigilant. And apart from this, the legislature and also the Supreme Court recent judgment has given a lot of importance to default bail, and the court has always said, of course, the recent judgments of all the Supreme Court are saying that whenever default bail is applied, the court has to apply its mind, and even if charge sheet is come thereafter, suppose you apply on the 91st day or 92nd day and charge sheet for 94th day and bail application is pending and there is no order pass on it, still the court will say that the bail application has to be considered. That is a right and statutory right of the accused and the fundamental right under Article 21. So this was all about default bail. I'm open for any questions, if any. You can unmute yourself now.
Hello, ma'am.
Hello.
Yes. My question is that if the bail is rejected by session court,
Yes.
and then we have applied for bail at High Court level.
Yes, yes.
Then in that case, charge sheet is filed. So what will happen?
See, default bail is about charge sheet is not filed within time limit. So you can apply to the trial court. Default bail will be given by the trial court.
Okay.
So you have to withdraw this application from the High Court.
Okay. Thank you.
Hello. Good evening.
Hello.
Good
evening. Good evening.
Sometimes we taken the permission from the court, honorable magistrate and consider court, and we take the permission for the more investigation because 60 days and 90 days is compulsory for everyone. Okay,
Yes.
in some act there is something provision in MOCA Act NCOC.
Yes.
In Maharashtra there is a 180 days.
NDPS Act also. NDPS also you can include.
NDPS also there is the commercial quantity and all things.
Right. They will apply for extension of the time.
Extension of the time to filing the charge sheet.
But you see, maximum period is available to them is 180 days. When this,
Yes.
see, National Investigation Agency, this act came in 2008. So all the scheduled offences are now through the UPA or all the other NDPS, all these scheduled offences will be through the national agency if it comes in the picture. This is one example. Now here, the time limit is 180 days. So you have to wait till 180 days and
Yes,
you
yes,
want
tell me,
to,
please.
yes,
No,
I
speak,
didn't,
please.
yes.
Please speak. Please, I'm listening you. I'm listening you.
Okay. So the time, see here the time limit is 180 days. And after 180 days, they cannot ask for extension, further extension here.
Yeah, but sometimes court is given to permissions, ma'am. In
No.
special
See,
cases.
now the recent judgments are very clear. M. Ravindran judgment, then Bikramjit judgment is also there. Bikramjit Singh versus State of Punjab of 2020. This judgment also says that it cannot be over annulled. It is indefeasible right. The recent judgments are very much in favor of the accused for default bail. Previously it was there. Now it is not so.
What happened, ma'am? Sometimes the accused is released, then his involvement, then sometimes he appeal to the another court, which higher court, and his bail is cancelled by police department, means the prosecutions. Okay, then we arrest him, re-arrest in the case,
Right.
taken the further custody once again, because sometimes a section is a minimized. Then for going in further investigation, we relied the higher section is maximum punishments. Okay, that time we cancel the accused bail, then we take the custody also once again. Then which date should be considered? The first is arrest date or second is arrest date?
For default bail, the complete investigation time will be considered for how many days he was in custody. Now your question is very peculiar, where you are saying that he may be re-arrested. right?
Yeah. Sometime happen because
Sometime
many
in
time
some
what
of these
happen.
he may be rearrested. I have not come across any such judgments, but whatever
Yeah.
I have learned from today's reading judgments before coming to
Because
the,
because I'm a police officer. Sometimes I am
I
arrested when
understood when you
accused.
said we
Ah,
are rearresting, but normally
yes,
the complete period will be considered.
yes.
Complete
Because
period will be considered. What's your good
which
name, sir?
control day? Ganesh Ande. Ganesh Ande.
Okay. Okay. From
Okay.
Maharashtra
Sometimes,
or?
yeah, Maharashtra. I'm presently posted at Airport Police Station as
Okay, okay.
assistant police inspector. Just completed my LLB.
So nice of you, sir. So nice of you for attending this. I'm really
Yeah.
grateful that you
No,
are
we are
attending
very
this.
grateful to be listening to your videos because we have a e-academy also in Maharashtra Police e-academy
Yeah, I know
sometimes
that.
because the police
Singada sir
officer
is
need to,
handling that, I believe.
yes,
Singada
Singara
sir
sir,
and three,
one
four
lady is
people
there.
from Osmanabad and Aurangabad, I know that.
Okay. No. Sometimes what happening, ma'am? Police officer having a facing many challenges. Want to take the quick decision. The complainant, which complainant come in the police station, we cannot quick.
But see, here I can apply only common sense because no such
Yeah.
judgments came that you have to completely, you cannot keep, see,
No.
police has unfettered power to arrest
Yes,
the
yes.
accused and keep them in custody. But 167 says that you cannot keep him custody for longer than the period which is already
Yes.
given by the legislature. So here it will
Correct.
be complete period we can apply the common sense that period plus this period when you are re-arresting.
Yeah. That is law is
Because as an
already
accused
got
lawyer, I
common
will
sense.
be counting all the days.
Maybe it will be the one kind of a different question, ma'am.
Yeah.
Which
I've
judge we
not
should
come
be
across
considered?
this. The default bail can be applied. First of all, he may not be granted bail also in such matters
Because
where you are saying he may be
what
rearrested. Because
what
the
happens
offense must be
sometimes?
very serious.
Yes, offense must be. Sometimes what happened, ma'am? Suppose one injured person came, okay, he admitted in the hospital. We are arrested the accused, okay, and he accused got the bail from the local magistrate or session court.
Then he
Yeah.
succumbs to the
Then
injury. Huh.
after some time, the injured person is died. Okay, the section will be added like a 302. The first section is a 326 because the minimized section he will
See, here
get the easily
I will
bail.
tell you something that here
Hmm.
the charges will be altered. Previously, it may be 326 or 324,
Yeah,
right? Or
325,
maybe
320.
307
Correct.
also. Now it is
Maybe
302.
302.
Now it will be
Yeah.
302. Those charges will
After
be
15 days.
altered. So as per
Yeah.
common sense, I would say you have to then start from the 302. The charge sheet for that you will get 90 days period.
Yes. That is. After release, once re-arrest him.
Yes, it will be 90 days because the charges are altered. As an
Alter
accused lawyer,
charge
I
is
will be
also.
saying that count those period as well.
The extra section is added as per
Yes.
the
Huh.
injuries and other things.
Yes.
Thank you, ma'am.
Thank you. Thank you so much. Any other question? Labdi has a question, but then it becomes a personal question. I would ask something legal, dear. We cannot speak about external influence. That is out of context here. If the bail is rejected, we have to apply to the higher courts.
May I ask a question, please? May I ask a question?
Hello.
Yeah, myself. I want to ask a question, ma'am. Are you hearing me? Can you hear me?
Your voice is not clear.
Okay, can you hear me now?
I can hear you.
Ma'am, the ED economic, the ED comes under NIA or it's under IPC for ED arrest and all?
Can
ED
you
arrest.
be clear? Vikrant sir, can you be clear?
ED arrest made by the police comes under NIA or it comes under NAVA? Like which law
It is
comes
under NI. Nowadays, we are not reading newspaper, but it will be under NI. All the scheduled offences are now under NI, which I read in one of the judgments.
Madam, in the whole CRPC, there is a word only the police, SHO, Session House in charge. No one
Yes.
is more than this SHO, Session House in charge officer.
Station
in the
house officer.
CRPC. In charge, having a vast power. CRPC
Yes,
gives
yes.
very vast
SHO has the vast power, vast power. That is true.
vast power. He can give the bail also.
Yes, you
169.
can. Yes,
Yeah,
yes.
some if a police arrested by any accused and his involvement is not showing in that criminal case, in any crime, police have powers to release, to take the bond and release the accused.
Yes, yes. Very true.
We actually have police not the submitting charge sheet. Police sending the fact finding to the court. Police have no power to make the charge sheet.
Okay.
173 is a clear cut of the fact finding to the proof. What is the fact found in the investigation? We should produce to the court and charge framed by the court, not the police. Is correct, ma'am?
Your vast knowledge, I
Charges.
really appreciate for sharing all
No,
this.
no, ma'am. I'm a practical. Just I'm telling
No.
more. I told.
I'm really thankful. Then I
Yeah.
got one more subject on 169. Maybe in future I'll take up.
You please take the 169 because the
I will try to take. I will definitely.
yeah, definitely. This is a very nice subject, and it's a very
I will.
knowledgeable part.
And
Because
thank you
of-
for suggesting.
Yes. If we produce the accused to the court, then we have a lock our powers. Police lock their powers of the 169. Because within a 24 hours, we have a limit to the 169.
167 is very good this subject, and somewhere recently Supreme Court has come out with very good, nice judgment, and this Bombay High Court judgment is very good, nice one. I will again share. Sainath
Yeah.
Bapu Salgare, Justice Bharti Dange, I believe. Surname is Bharti Dangre. She has beautifully written this judgment, and it's really nice. And she has discussed all the judgments of the recent Supreme Court. So if you, for this anybody who has a difficulty in the default bail to understand, this is one of the judgment of the Bombay High Court, very recent one, which covers all the judgments and all the issues. She has addressed all the issues here.
Sometimes time is considered, ma'am. Sometimes time is considered because we are the practical. Suppose I submitted the charge sheet, means final report in the court 11 o'clock in the morning. Okay. Then accused lawyer advocate approached to the court 3 p.m. Okay. He's also
In this case,
not get the
same
bail.
thing has happened. Same thing has happened.
Because, yeah, after 4 hours, the accused advocate is approached. So that's why when sometime.
So once see here in para 16, if you can see, in the present case, the applicant exercises option to obtain bail by filing an application at 11:20 a.m. Now, purposely here time is given by the accused lawyer in this matter, but he was granted bail.
Bail.
And there were some other factors also.
Depend upon the court. Yes. Depend upon the court.
Depend upon court. But recent Supreme Court judgment, if it is filed on the same day, still the bail application has to be considered for default bail.
Yeah, correct. For this new judgment.
Because of this new judgment.
It is happened before 6 months. I given this example before 6 months.
Okay. Thank you so much. Okay. Thank you so much. I'll end the meeting for today. Okay, good night, everybody. Yes.
I think, ma'am, is session house officer. This position is at only metro cities or the commissionerate level. So, in rest of the area, suppose in district level, I think this post is not there.
I'm not.
As the police hierarchy is concerned.
The police personnel can answer this. I don't have the knowledge about this.
Repeat the question, sir. Repeat the question.
So my concern is that the session house officer, that post is only for the commissionerate level cities.
No, sir. SHO for the anyone. The rank of the head constable and above. The rank of the head constable and above, sir. It is not the commissionerate or the rural area. Okay. It's fair. And the investigation, we do the investigation throughout the India.
Okay. So he has a right of.
Yeah. Head constable and above is the SHO in anywhere in whole India, man. In whole India.
Okay. Thank you, sir.
Thank you so much. I'll end the session for today. Good night, everybody.
Good night.
Good night.